That's very fundamental, and that's also in accordance with Section 4.1 of the Fair Administrative Action Act, which, more than even the standing orders, requires that you must know the case you are facing. You must have the documents. Mr. Ouko does not have a single document to respond to, not a single one. He only has bare allegations. Having been allowed up to tomorrow midday to go and present a fresh memorandum and to bring the documents, Mr. Chairman, then it means that this committee cannot proceed to wish to hear Mr. Ouko when the petition is incomplete. The petition has not, he only came up to paragraph 15. He has not presented any document and is going to present a memorandum. What that would mean is that the Auditor General is being asked to respond to an incomplete petition. Mr. Chairman, that would go against every grain of natural justice. And the third one, which is the last one, is this, Mr. Chairman. Again, under Section 4.3F and Section 4C of the Fair Administrative Action Act, anytime anybody makes any statement that is adverse to you in a quasi-judicial process, you must have the right to cross-examine them. We duly gave notice in our letter to you, Mr. Chairman, copy to the Speaker and the Clerk, that we will be seeking to cross-examine the petitioner. We will stand guided whether it is the committee's position that that act applies or not. But it was our intention, once the petitioner is done, and before Mr. Ouko is asked to now present his case, to ask him a few questions that are important in terms of the preparation for Mr. Ouko for his case. So the crux of this, Mr. Chairman, is that it is our position, is the position of Mr. Ouko, that while he has taken time to respond to the substantive allegations, those allegations ought not to be looked at unless this committee makes a determination of those preliminary matters. But even before those preliminary matters are raised, and we've therefore not raised them now, it is a fundamental procedural issue that Mr. Ouko ought not to be asked to respond to anything until the petitioner has finished presenting his case. Only then can he respond. And therefore it is our plea that this committee adjourns to tomorrow. We see what additional memorandum the petitioner has. We see what evidence he has brought. We get a copy of that evidence. Then the response by the Auditor General can be complete. That is our request.
So members, on the question of putting whoever the witness or the respondent or the petitioner onto oath, if you look at the National Assembly powers and privileges, that is clause 16. Yes, it provides that witness may be examined on oath, yeah, but it's not compulsory. It says it may, yeah, it may. And the reason why we are not doing some of those things is because all these proceedings are actually under answered, yeah. So all our proceedings are recorded, and we have all our staff there. That's why the reason we don't even if we have not required you to swear an oath, because we'll still have done so. Shakir, what do you?
I have been a member of this committee on various occasions when people have come even to give evidence. We have made them swear under oath, even smaller issues. So I wonder whether we made a mistake, and now if they've made a mistake, let's admit it and have them sworn under the oath. I think it's very simple.
Chair, we've taken people oath when they come for office, when they're being appointed to our office, is when we have done it. We have not done it before, Honorable Shakir.
Other members, I think the law is there. It's not a must. Yeah, the law is there. Yeah, it's there. I've just read to the members. So members, we have had a wakili for the Mr. Ouko. But yes, Sakaja.
Chair, even as we dispense with the preliminary issues, because we must dispense with those before getting into the subject matter. I think it is important to just note, since we can see a very comprehensive response already prepared by the Office of the Auditor General, and it's a response to the petition as it was provided. I think it's important to note one or two things. Number one, the petition as it was, as received, based on Standing Order 223, was complete, even without the additional, information. And there can be a response to the petition as it was, or rather as it is. The request for additional information should not then prevent the Auditor General from making a response. In fact, if anything, I could be tempted to think that the response then by the Auditor General could as well, remove a lot of these issues from discussion. But also, Chair, secondly, I think it's also important, to clarify that on the matter of oath, that even on the request of any member, during any sitting, at the request of any member, petitioner, or any witness before us can be taken, can be asked to oath. And in the subsequent hearing, that can be done. In any case, if the petitioner has brought an affidavit is also sworn. And that has a similar weight in law as an actual oath, because it's a sworn affidavit. So, Chair, I would request that we can dispense with the preliminary objection, get into the subject matter, and then also give, because of the fair administrative action, be able to accord the Auditor General, through his legal counsel, an opportunity to also cross-examine the petitioner. I think that is in order for the committee.
Thank you. You have something to say, member for?
Chair, I happen to concur a lot with the Honorable Sakaja on this, on most of the substantive issues. First, for the record, my name is TJ Kajwang, a member for Waraka. This is not a court of law. It's, you may call it a tribunal, but it has quasi-judicial powers, of course, which can affect the rights of an individual. And that is why, even in a quasi-judicial system like we have to be very careful and very sensitive to the issues of rule of law, so that we don't besmirch people's characters without giving them an opportunity to be heard. But the procedure and the system is fairly in-house. It is true that the petitioner has made a petition, and the respondent has made some response. To that extent, as Honorable Sakaja says, it's complete. But of course, there are issues of documents which we need to examine. And Chair, you had ruled, and in these systems, one of the things we do, we do not go against, we don't question decisions by the Chair. The Chair had said that the petitioner will come tomorrow, or he will file documents between now up to tomorrow. And based on that information, members may wish to investigate more on those information. If then those documents come, because sometimes they may not come at all, but if they come, then they will be subject to investigation. And then the respondent, or the subject, sorry, let me not call him, he's not a respondent, it's a subject. If the subject chooses, he then can make also interventions based on the records as we will receive them. So I think, Mr. Chairman, I take the view that we should relax the procedure. And again, you see, this information has gone to the media. And sometimes people will use parliamentary procedure to besmirch people. He comes and say things, and then he's gone, he's not even coming back. So you will not even have an opportunity to respond to him, and the time to respond is also not there. Knowing that these systems, this petition procedure is also circumscribed within some period of time. There is a period of time which we must make a decision one way or the other. So if we prolong it, you also don't have the chance to speak to the nation the way the other person has had a whole day to speak to the nation. So it is you who is injured. at the end of the day, because you do not have an opportunity to speak your mind.
Thank you, Member for Warak. I think Mr. Ouko and your counsel, as Honorable Sakaja has mentioned, the petition as it is, as it is complete according to our standing orders and procedures. Number two, if you look at in the law and in our standing orders, there is nowhere where the petitioner is required to come and defend his petition. But what we do as a committee is we give, nature of justice, we give him the opportunity to make a presentation. You'll have chosen to say, rely on what I have submitted to the committee and make your own decision. Even you as the affected person, I believe this is your opportunity to clarify the issues which have been raised. And I think it is to your advantage that you take the opportunity to clarify the issues which have been raised, because you could still choose to write to us a document and respond and say, I don't want to be heard, I don't want to be questioned. You just write to us a document and say, let the committee decide based on what I've written. So it will be up to the committee to use the document you have versus what the petitioner has. So, but I think we give the opportunity to the petitioner to actually to give us additional information or to support his written petition. And we also give you an opportunity to come and respond to the issues that we have here, so that you clarify and say this is not, and the committee now will have heard you on both sides, and the decision will be up to the committee based on the information you give. So to me, I think as if I were in the position of your counsel, I would say we take the opportunity to clarify the question, to put the record straight, where you think the petitioner has said the wrong things about your client. So I think let's proceed. And by the way, before the petition is brought to the House, let me just clarify that before the petition is read to the Speaker, is read by the Speaker in the House, there is always, Mr. Ouko, before the petition is brought to the House, there is a backroom check on whether it complies with the standing orders and the law. And actually, by the way, if you look at, I know you said it was fast-tracked, but if you look at the same day the petition was brought, then the legal team made an advisory. The advisory dated 14th of February and confirmed that all the requirements of a petition have been done, and the letter is here from my legal office. And so there is a backroom checks. And again, the reason why it normally takes short time is because the petition is timed. 2 weeks, 14 days. And within 14 days, you also have supposed to be given 7 days. That's why you cannot be called earlier than 7 days, because you are supposed to be given 7 days to prepare yourself. You are given a notice of 7 days. So within 7 days, and then the committee must work within that framework. That is why, when the legal process is done, then the other processes of taking it to the media for people to submit memoranda and so forth are there. So I wish to confirm that there were backroom checks, and the letters are here from our legal department. Yes, sir. Mr. Ouko.
Mr. Chairman, I appreciate the explanation you are giving, and the fact that you feel that this thing was not fast-tracked. That I feel is really not in a reading what I'm seeing. This is the removal of the Auditor General, a petition which is incomplete or which hasn't given me any information about what it is about. A petition which came here, and even I was here, you are still asking for documents, and sometimes it's going to print accounts. It's going to print what? To bring here again. And it has been accepted from it. You received it on the 14th. It's done fast-tracked, and it brought to the committee on the 16th. And yet, if you look at the the background to all this, it has been everything about Mr. Ouko is being fast-tracked. It was even said even by the DPP. So I beg that really we must give a fair hearing to this very important issue. And I think to say that it has not been fast-tracked, to me, in fact, you wrote to me on the 17th, which I received on the 20th, and you are asking me to come on the 23rd. Is that not fast-tracking? Sir, I beg to feel that I'm being unfairly treated.
Well, I appreciate the position which you hold, and I want you to relax, Mr. Auditor General, because you know you have been accused, and the best you can do now is, to give us facts, so that the committee can make a decision. If we go further and say it's like it was fast, this is the same procedure which is applied if today somebody wanted to remove, say, control of budget, say, commissioner on any commission, because the procedure is the same. Yeah. Order. We are talking about constitutional commissions and independent officers. So I want to assure you that even if there was another petition today for removal of all those independent commission holders, be the chairman of EACC, chairman of salaries and remuneration, those constitutional commission and independent officers, which one of them is Auditor General and I think controller of budget. The same procedure will still have applied, because according to the law, this must be dispensed with 14 days after. Yeah. So the procedure is not special to you. It is a procedure that will apply to anybody in that category of public servants, which is actually in the law. And maybe my class can advise me on the sections of the law which apply to the process of dealing with the removal from office, so that we demonstrate that the procedure is not made specifically. It's not about Ouko. It's a process which has been created in law, and members are here who made the law.
Sure.
Yeah. Is it? Well,
Mr. Chairman, if you allow me, we've consulted with Mr. Ouko. This is what we propose to do. The preliminary issue we are raising, and I think you're here to rule on, is whether it is fair to allow Mr. Ouko to respond to part of a petition. Then the petitioner will bring the rest of the petition and the documents tomorrow, and that then he can respond to earlier. But that was the preliminary based on today's proceedings.
Mr. Wakili, I think yes. I've already talked about that. I've said, as it is today, yeah? And by the way, you can refer to our standing orders on the petitions. As it is today, this petition, the petitioner may have chosen not to attend, yeah? But the committee will still, with the information they have, the committee will still proceed, because it is assigned, what do you call, it is on oath, yeah? So the petitioner assigned the petition, he would still have chosen. There is no in the law or the standing orders on petitions where we are supposed to force the petitioner to come. But we call him because we say he needs to give additional information, which he may choose and say, that is all I have, deal with it as a committee. Even you and I have said again, Mr. Wakili, that even you, the Auditor General, you may choose and say, I'm not responding, or I am giving a written memoranda. So according to the committee, deal the way you want. But we are giving you an opportunity to clarify, so that the true position may be known by the committee. And so maybe I should read to you the 230. Maybe maybe because you are raising questions on procedure for the petition, I should read to you the Petition to Parliament Procedure Act. That is clause 5, which talks about consideration of a petition, and says the clerk shall, if satisfied that the petition meets the requirements of this act, forward the petition to the Speaker of the relevant House for tabling in the House. Yeah. So the clerk shall, if satisfied that the petition meets the requirements of this act, forward the petition to the Speaker of the relevant House for tabling in the House. A petition that is tabled in Parliament under this Act shall be considered in accordance with standing orders of the relevant House. The Clerk of the relevant House of Parliament shall, within 15 days of the decision of the relevant House, in writing notify the petitioner of the decision of the House. Of course, that is the general. Now, this is the petition on removal. Yeah. So, may I read to you also the standing orders? 230, and the heading of that section is petition for removal of a member of a constitutional commission, which by extension, holder of independent office. In addition to complying with the requirements of paragraphs A, B, C, D, E, H, I, J, L, and M of standing orders 223, which is the form of petition, that is how the petition should come. A petition of the House for removal of a member of a commission under Article 251 of the Constitution shall indicate the grounds under the Article 251(1) of the Constitution which the member of the Commission is in breach, and B, may contain affidavits or other documents annexed to it. So this one gives an exception to the petitions on removal of members of commissions. If you read the one for 223, which is the form of the petition, you will realize that the general petitions, not the one for removal of commissioners and members of independent commissions, it says that a petition shall come, naked. You don't attach to any evidence. You just bring a petition, and then it's Parliament to look for the further information. So now this one says may, but of course it does not say must. Yeah. Then among other things. Among other things, says number 4, upon the receipt of a petition under paragraph 3, the relevant departmental committee shall investigate the matter and shall within 14 days, so you mark 14 days, report to the House whether the petition discloses the ground for removal under Article 251 of the Constitution. The House shall within 10 days of the tabling of the report of the committee under paragraph 4 resolve whether or not the petition discloses a ground for removal under Article 251A of the Constitution. Number 6 says, where the House resolves that the petition discloses a ground for removal, the Speaker shall within 7 days of the resolution transmit the resolution and the petition to the President. So I just wanted you to know about the 14 days so that you know that the activities that preceded. You said you have 2 days, 3 days to abstract.
There's a point of order here, Mr.
Yes.
Chair. I think and I'm not speaking for this, what I understand is asking for administrative justice. As a member of this committee, I stand a little bit confused. Whereas the petitioner did not turn up last week, and we gave him over a week to turn up. Now we are using that time. We gave him time to turn up, right? So the same administrative justice that you're talking, what we're saying, it appears that some of us are using a double standard, whereas we are giving petitioner, we are bending over backwards for the petitioner. Where am I out of order? I'm only sharing
you
what...
can only say that...
I'm only sharing...
You can only say that if the Auditor General who is sitting before us...
No, I'm as a member of the...
As requested...
No, I'm not...
Order, Shakir.
I am not fighting for the Auditor General.
You can only say that if the Auditor General who is sitting before us has requested additional time to prepare himself, and the committee has refused, you can say maybe, no, but we are not even yet there.
I'm just confused, Mr. Chair, as a member of this committee, and a member of the committee itself, that we went over backwards. And I remember, Mr. Chair, that I'll complain bitterly that we don't need to give this gentleman so much time, especially when we have such a tight schedule.
But in fact, there is even further information. In fact, none other than the Auditor General himself did request for additional time through a letter from Raja Omolo Advocates, and they actually requested that we give him time up to today. Isn't that right, Mr.?
That's correct.
Yeah.
Yes. And I think Council want to add something.
Yeah.
Mr. Chairman, I was going to help this committee by giving the indications of our discussion with the Auditor General.
Yes, yes.
And I was going to indicate that this was in three parts. The first part, which I think you've ruled on, so I'm not going back to it,
Yes.
was the question of requesting that the Auditor General be allowed to know the whole case that he's facing and not part of the case. Because the petitioner has only presented part, he'll present a memorandum tomorrow and the evidence. But I think you've ruled that nothing obligates him to provide any documents or even to appear. Now, I believe then you will rule on if he presents those documents or a new memorandum, then you will guide the Auditor General whether he needs to come and respond to that in addition. Our thinking was that procedurally it would have been fair and easier to allow a petitioner to state his whole case, then ask the respondent to respond to the whole case. That's all we are saying.
I think let us,
but
Wakili,
we've left that.
let us proceed, Wakili.
Yes.
With because we have one we have agreed
Yes.
that the petition as it is,
Yeah.
is complete. Yeah. The petitioner would actually have chosen not to appear at all. So that means we would have just used what we have, whether it makes sense. Then the committee will decide whether there are grounds or not. Number two, you also agree with me that we didn't complete, but the accusations are different. Yeah. We have different accusations, and we have covered quite a ground on different accusations. Whatever remains, we can agree and say where we reach with the petitioner, we can stop there if that being the case. But nothing also stops if the Auditor General will want to come back in and clarify further issues which may come up. He'll still be at liberty, of course, subject to time. Yes, yes.
Chair, I think the petitioner finished all in brief and then went back again to explain. So he did not leave any part of it. So the whole petition he executed initially in brief, and then he was just going specific because we wanted to ask him specific questions. So I believe he did the whole thing.
So members, unless the minority whip wants to say something, minority. And I have seen he has done a good whipping.
Thank you, Chair. My name is CPA Thomas Madegu, a friend of the committee. I would like to declare my interests. I know Ouko. He's a colleague in the Institute of Certified Public Accountants, and I know him very well. Chair, following the procedures of Parliament, I would have thought that it would be prudent if Ouko responded to the issues that have been raised. And if other documents are tabled, he has a right to come here and respond to all those documents that have been raised. Right? That's one. Chair, all the same, he may seek dispensation from the committee that he knows the entire case, because those documents may come with evidence that is not related to what has been said, so that he may know entirely what it is. Now that will depend on his request. But as it is, since a lot has been said this morning, could be what the committee is asking, can Ouko respond to some of those issues? And if other
thank you. I think you are speaking my language, so
he should be given an opportunity to respond to all those matters. The issue finally, Chair, of fast tracking, I think the 14 days period is standard. But could be what Ouko is saying is these 14 days have been consumed even by the time you're writing to him, giving him time and what have you. He feels that he is not being treated fairly. I think that's the position. It's a feeling,
okay,
Chair, you have an obligation to put it right, that you are within the standing orders.
Thank you.
And that there are petitions which take more than 14 days. He's questioning why he is being rushed so much. And yet there are others, there are very few petitions which have followed the 14 days period. I think that's the point Ouko is making. And I think you have an obligation, Chair, to clarify that point.
Mr. you know, this gentleman is my senior in the profession, and he was once my boss when we used to be in another committee. And I think, Mr. Mwadegu, we had actually dealt with that matter earlier when we had said that on the question of whether he was hired. Surely, I have produced a letter which he requested an extension of time, and which was agreed to today. Today's date was his date. He said he wants to come today from some date. Number two, you should also appreciate, Mr. Wadeu, that this is not the ordinary petition. This is a petition to remove a constitutional office holder, and there is a special procedure for that. And I've read the standing order, the relevant standing orders, which talks about 14 days. Certainly, I think you are just you are not in the house. So we have read the standing order, which talks about 14 days, and I've also confirmed that the way we have handled this matter is not special to the Auditor General. It will still use the same, or any other committee for that matter, will still use the same procedure and timelines to transact such a petition. Of course, we have other ways. If we found that time is not allowing, we have other ways of seeking extension from the House, which is also another procedure which can be used by any other person if time is not will not allow. So, having said that, I think members, we have said all manner of issues that needed to be raised. Let us proceed. Let us proceed with the Auditor General. I hope you, Boru, you will not take us back to.
No, I will not take you back. Mr. Chairman, when it says we may means that it is our discretion to decide whether we want the petitioner to give evidence or not. Now, in this particular case, we have decided to ask him to give us those documents. And there is no provision in that particular standing order which allows him to refuse, the way you are putting it, Mr. Chairman, that he is not obligated. Once we decide that he produces those documents, he is obliged to produce them, because this is a very serious issue. And that word may was put there because of the seriousness of the nature of the accusations before us, because it is not in relation to any other except the removal of a constitutional office. So, Mr. Chairman, don't put it as if that man can decide not to bring those documents. He must bring them because the committee has decided that he brings them, and we require those documents by tomorrow, as was requested, Mr. Chairman. It cannot be optional for him.
Yeah, you are right, because we have
get the information that it is
because we have ordered it. But if you could have still said my petition is complete the way it is, let the committee. You know, let me maybe I should say this. You know, the petitioner is like what can I say? Like a public prosecutor. He says this is the case. So if he doesn't produce the evidence sufficient enough to, you know, to let the person accused be prosecuted, then he loses. So it is him who has the interest to succeed. If you wanted the case to succeed, to bring the evidence, it is also the interest of the accused person to say, you know, to defend himself and produce documentation which is sufficient to, you know, to counter the petitioner. So members, having said that, I think we should then proceed in the same manner we did in the morning, that we proceed in an orderly manner. One, the allegations are specific, and therefore we'll move in that direction. Say, allegation number one, what do you say about the reporting to Parliament, the reporting to President and Parliament?
Mr. Chairman.
Yes, sir.
If you allow me, how much time does this committee wish to give Mr. Ouko to respond so that we know how to reorganize internally?
members. Members are saying whatever time you need, but members, we have a practice in this committee that, and I've been telling members, it's not written anywhere, but I've been saying you must be brief, concise, and precise, so that we respond specific to the specific issues, so that we save on time. We'll encourage you so that you cover enough ground. We encourage you to save time, Mr. Ouko, because the allegations are very, very specific. For example, in the first one, I don't think we can take 5 minutes. If you say, yes, we have not been reporting, or no, we have been reporting, these are we reported on these dates, you know, and then we go. Then the other thing is we have to confirm from, say, if the allegation is Parliament, the clerk to Parliament will say, okay, did we receive the report? No, not. The presidency, same. Then that's all. Then we move to the next things, which are also fairly specific, Wakil. So there is, in the morning, the petitioner was here, and the first allegation was failure to submit reports to the President and to Parliament pursuant to Article 2541. I'm sure you, being a lawyer, you are up to speed with the 2541 of the Constitution.
Mr. Chairman, just as you allowed the petitioner...
And I will request that let the Auditor General himself speak.
Yes.
Unless he requires you, and then he will speak first and then give you to... So that it's not like we are dealing with you directly. Or I don't know. I don't know, maybe because it looks like we'll be interrogating your lawyer.
No, Mr. Chairman, yes. I've been involved in doing this, and that's why I decided to make sure that this thing is complete. I decided to respond to it, and we prepared with my lawyer, and I think he's in the right position also to speak for me. Right. So when he speaks for me. So that's all. So I've just asked if he can now clarify on the.
You know, Auditor General,
yes.
I expect you. You know, these are fairly. You know, about reporting. Yeah. About reporting. Under 2541.
Okay. Surely, are you dispensing with me so that I leave or what? Because the Speaker wrote a letter saying he's entitled to counsel. I was admitted here as counsel, and if I cannot be allowed to speak or guide, then it means I'm being evicted, and I'm happy to leave.
Nobody's evicting anybody, but we are saying, at the end of the day, it's Mr. Ouko who is, yeah, and I think Mr. Ouko should say yes, no, and then you can clarify on the questions of law.
Mr. Chairman, what I was going to say, and I'm familiar with these procedures, I'm the first ombudsman of this republic, that in a committee such as this, interrogating a state officer, there are certain obligations of the state officer to respond to specific issues, especially relating to issues of removal from office, upon advice, and to those he will respond specifically. And he has responded to each of them. But Mr. Chairman, two things. One, the manner in which he responds should not correspond to the manner the petition was presented, because then you are limiting him. I think once, and that's why I sought the time, how much time we have, then he responds. But more importantly, Mr. Chairman, as his advocate, on issues of law, I thought, Mr. Chairman, that the Honorable Chair and the committee would allow me to indicate one or two things only on issues of law. And one of those, and that's why you will see that we've taken time to make the work of this committee easy. We have not jumbled up issues of law and issues of fact. The first part A, B, and C are only of issues of law. Now, you have guided, Mr. Chairman, you have guided, and we are not going back to your guidance. What we had agreed on was this. To make the committee's work easier, and although we had done a letter saying we'll raise some preliminary objections, we have consulted, and what we proposed to do was merely to give those indications, not ask you to rule on anything, because this committee will retreat and consider everything.
Yes.
So when you retreat, you will then consider the points we raised of law. Are they merited or not? If you find they are merited, even at that stage, then you will dismiss the petition. If they are not merited, you will indicate why, and then you come to the substance. So what I was proposing we do was that in a very summarized manner, we will just indicate the 5 or so major points of law which you will consider when you retreat, and then without any interruption, Mr. Ouko will then take you through the substantive response. to the petition.
So then you should
if you agree.
move very fast and move very fast so that we save time. Yeah.
Thank you, Mr. Chairman. Let us start with the issue of fast tracking. It is this Ouko's position.
I don't know now because
it's an issue of law, Mr. Chairman.
Because I thought we left that place.
No, we did not submit on it. We just said it. We want to.
I thought we are now in the stage where we left that stage. We are now in a stage where we are responding to the specific questions of, say, because I read to you the standing orders. Didn't I read to you the standing orders?
Chairman, you have been misled by the legal department, and I wanted to point that out.
Order.
Only.
Order. You know, you are a lawyer. Yeah, you are a lawyer, and we also have lawyers. Yeah, and it doesn't mean it doesn't mean you are a lawyer better than the lawyers we also have. Yeah. No. So that language of misleading.
Mr. Chairman, I withdraw.
And let me tell you, let's not concentrate on the sideshows. Yeah, because the way I'm seeing you proceeding, you want to pass a line which is, sideshows. The accusation which is facing are serious. So you do justice to him by concentrating on the issues, not on the sideshows of saying you are missing. I've read to use the standing orders, yeah, and unless you told me the petition was brought to the House before it reached the Speaker, before it reached the clerk, then that would be a different matter. But 2 days for something which is timed for 14 days is not a. And I have gone a long way to say this is not a specific procedure for the Auditor General alone. This is a procedure we'll even follow for any other public constitutional office holder. So, where I said I thought, and members you should correct me whether I'm wrong. I thought we had left and said now we are addressing the specific issues. Yeah. Now when you take us to the preliminaries, and we don't. Yeah. Unless you don't want to. Yeah.
Can I explain myself, Mr. President? You are saying that this is a very important petition. It's perhaps the first one which has come which is being handled in the new constitution. Now, I have raised issues which I feel there's been administrative justice, which I think should go on record, even if at all we are going to consider the substantive element. And that's what we want now, to raise these substantive issues of law, yet I'm going to go through the substantive issues of facts. And I think it is only fair that we make sure there's a precedent, not to gloss over it. Yes. Because it will inform the next person, if not Mr. Ouko today, it will be somebody else. So let my legal counsel at least say my point.
Even as you say that,
Mr. Chairman.
Auditor General, even as you say that, and I know, of course, you are affected, and I know you are bitter about it, but it's something which has come and which we must address as a committee. And by the way, this is not the first petition in Parliament to remove a constitutional office holder. Of course, it might be the first in this committee. Yeah? It might be the first in this committee, but we have had others under Justice and Legal Affairs Committee. We have had others under, I think there was a petition to Ministry, the Minister CS for Education then, yeah? And yeah? But I mean for the constitutional office holders, the procedure is there in our standing orders. We have read the Petition Procedure Act. But I'll give you, if you want to transact, if you want to engage in those lines. Okay, please proceed. Yeah, yes.
I think, Mr. Chair, it is fair to allow the subject to prosecute his defense in the best way he knows how. I think all we need to do is we have time that we have to live by. We can't be here after midnight. So what you do, we give them time, and then within that time, it is upon them to know how much information they're going to put,
let's
which
listen to
way
this.
they're going to do it.
Yeah. Okay. Let's listen so that you don't we don't go saying. Okay.
Mr. Chairman, we will be as brief as possible. The first issue we want to start with is the issue raised in the preliminary observations. It's page 1 of the response, and it is the issue of fast tracking. Mr. Chairman, this petition, the affidavit was sworn on 13th of February. It was filed in Parliament on 14th of February. On the same day, it appears to have been committed to the clerk, and on the same day, it appears to have been committed to the Speaker. Mr. Chairman, what must guide the clerk on receipt of the petition, as you observed, is the Parliamentary Petition to Parliament Procedure Act. I draw your attention, Mr. Chairman, to section 4, subsection 3, procedure of presentation of a petition. When the clerk receives a petition, he has 7 days to review it, not 1 day. 7 days, section 4, subsection 3. And he must review within 7 days of the date of receipt of the petition, and then review the petition to ascertain whether the petition meets the requirements of the Act. It is not conceivable that on 14th the clerk received it, he has 7 days, he acts within 1 day, on that same day it's committed to the advisory committee, on that same day the advisory committee is satisfied, then he takes it to the Speaker, and then on the basis of the letter that the Speaker has done previously, Mr. Chairman.
So please read this, the particular section.
Section 4.
About 7 days, is it?
Section
After 7
4.
days or within 7 days?
Section 4.3, it says within 7 days.
So
our point is that the clerk had 7 days. He acted within 1 day. That is fast tracking. That's what we are saying. On that same day, it was committed to the advisory committee. It is not clear how much time the advisory committee has, but for some reason, that same day, they looked at it and they were satisfied, which is strange. On that very day, it was committed to the Speaker. That is the third stage, Mr. Chairman. When it's committed to the Speaker, and we have the letter by the Speaker on previous petitions, the Speaker has a statutory duty, and I draw your attention, Mr. Chairman, to the annexure to this petition, to the response from page 15. You will see that there have been previous petitions of a similar nature. One was by Apple Lomboya, the other was by Michael Ngugi. I draw your attention to the second one by Michael Ngugi, the letter of 16th August 2016, signed by the clerk. Yeah, it is, yes, look at page 8. On page 8, you will see there was a similar petition by Michael Ngugi, and I draw your attention, Mr. Chairman, to the page 8B, that is, if you turn overleaf. You see under part 3, the petition was committed to the departmental committee. It was actually this committee. And then number 4, it indicates that it was received by the Speaker of the National Assembly. I address your attention to number 5, where it is said, as you may be aware, the Speaker is constitutionally obligated to interpret the Constitution and standing orders of the House on matters touching on the proceedings and business of the House. Mr. Chairman, go to number 6, sub D. Even if the Departmental Committee on Finance, Planning and Trade were to proceed to consider the issues raised in your petition, it would not be in a position to resolve them. That was committed, and that petition was being recalled by the Speaker. It was to this committee, without this committee considering it. Why? Because, as he says in E, your petitioner failed to indicate whether any efforts have been made to have the matter addressed by a relevant body and whether there have been any response from that body or whether the response has been unsatisfactory. In this regard, therefore, your petition is as submitted and originally committed to the committee is inadmissible for the reasons stated. I'm urging that at that stage, the Speaker, having received now the petition after the advisory committee, before presenting it to Parliament, needed also to examine it and be satisfied that it merited commitment. That was done. That was done on 16th. The very day that was done, because on 17th, an advertisement inviting public views on the removal of the Auditor General appeared in the papers. What does that mean? As the matter was on the floor of the House, there was a parallel process to send the advert and invite views and submissions on his removal. Within 2 days, Mr. Chairman.
So Mr. Wakili, you have raised one question is on timelines. Yeah? You say it was fast-tracked. So is there anything you are objecting on the petition itself? Because, you know, it says within 7 days. Yeah? Within. So 1 day is still within 7 days. 2 days is still within 7 days.
But Mr.
3
Chairman,
days,
this
yeah.
reveals malice. Yes.
Guru?
This reveals that there is something which is happening within here, that somebody is targeting somebody, because really it has not happened. I've been here for more than 23 years. I've never seen, there have been so many petitions, even against the speaker, but it has never happened that way.
Members, yes, let's listen to our legal counsel also.
Chair, let me address the issue which Counsel for the Auditor General has raised on the issue
But
of...
I think there is an issue of procedure here, Chair.
Order.
If we are going to argue back and forth with the subject, we are not giving them time. I think what we need to do is to give them time uninterrupted. They say whatever they say, even if they say whatever they say is unpalatable, let them just say it and say everything. Because if Council is going to respond here, it is as though we are deciding those issues as we go on. Let us just hear them, keep them in stock, and then we will deal with them at the point in time when that is necessary. They are the ones who have the response. Let us just listen with them uninterrupted. That's what I think.
But,
as a question of procedure.
But you also agree with me that there is the element of time. You are the one who...
Give them time.
You are the one who...
They say whatever they want to say within that time.
Okay. So
Chair, with due respect, I wish we could give the petitioner time.
Order.
Because what we are doing...
Order. Let's listen to legal counsel also.
Submission on that issue.
Okay, let me give you another 2 minutes. Order. Let me give you another 2 minutes.
On that point, thank you, Chair. 2 more quick points. Number 1, Chair, the standing order number 230, in terms of 14 days, does not apply from when the petition is filed. It is from when it's committed to this committee. So it is not true that the 14 days starts running from when the petition is filed. 230 sub 4 is very clear. Upon receipt of a petition under paragraph 3, then the relevant departmental committee. The 14 days applies to this committee, not to the clerk, not to the speaker. And that's the point we were making, Mr. Chair. It is only once you've received it that the 14 days start running, and I agree with you on that. But we are addressing the question of the rush of committing it to this committee. My third and last point on that in 1 minute is, Mr. Chairman, you will also need to address the question of the apparent conflict of the standing orders. Standing order number 227-2 and 234 in the following manner. Under 227-2, this committee has 60 days. Under 234, the committee has 14 days. Why do I say that? The only standing order that guides this committee on committal of petitions is 227. There is no independent standing order that guides committal under 230, which means once it is committed, you have to come back to 227. Now, 227, which deals with general petitions under Article 119, gives you 60 days. 230, that deals with removal from office, gives you only 14 days, but does not have any provisions on committal. Now, so what does that mean? That means you will have to decide. To the extent that this petition, and you look at the heading of the petition, purports to be brought under Article 119 of the Constitution, and this standing order from 223 to 229 relate to petitions under 119. This committee will decide, and it's not just for this matter, Mr. Chairman, I think it's for all matters, whether you want to constrict your timelines to 14 days under 230 or to 60 days under 227. That's my only submission on the fast tracking.
Okay, have you done?
On that issue,
Okay, so legal counsel, you can proceed to
just to respond
whatever
on
you
that
want.
issue.
Yeah, on that issue, and then I will come to the questions of the standing order.
Chair, I just want to respond on the issue of fast tracking, because counsel rightly pointed out that when you look at section 4.3 of the Petition to Parliament procedure, the clerk of the relevant house shall, within 7 days of the date of receipt of the petition, review the petition and ascertain whether the petition meets the requirement of the Act. So immediately, the clerk received the petition, he had 7 days within which to ascertain whether it meets the requirements. When you look at the actual petition, with the original one, which is with the chair, the clerk found the petition, he looked at it, he referred it actually to the legal directorate where I serve. And the legal directorate were bound to check at the standing orders and the constitution, and even these are serious petitions for removal of office. We were supposed to satisfy ourselves that the petition meets the threshold on the face of it, which was done, and the clerk was advised that the petition meets the standards which require for it to be referred to the speaker. The legal advice actually is also with the chair. On the same day, yes, incidentally, on the same day. The same day again, the clerk advised the speaker, and the speaker referred the matter to read a communication to the House, saying that the petition, that is on 16th of February.
No, point of order, Chair.
Chair, what I want to say is, nothing out of order, relax. In the time range within which the Act and the standing orders provide, the person has been referred according to the time range. What I would rather hear the council complaining about is that the time maybe has been too short, and they have said that they have been given additional time to respond, because the only issue which can arise here is not bad faith. It is the issue of whether there is sufficient time for the respondent to answer the issues, which I would rather they address the issue on the injustice or the prejudice caused by the fast tracking. But the fast tracking in itself actually just demands that the justice delayed, justice denied. So the faster it moves, unless it prejudices the respondent, in itself should not be a ground for objection. And I think the clerk and the speaker acted within the time range set out in the Act and the standing orders. So thank you very much. Thank you very much. If it was 8 days, we will have a complaint. So if it is 1 day, 2 days, 3 days, where I sit as a chairman, of course, we have noted your comments on fast tracking, but maybe that is fast tracking from where you sit is bad. But sometimes also, I heard Sakaja saying maybe we are also very efficient in Parliament.
Chair, you know the Honorable Counsel was the first ombudsman of this country. He was in charge of the Commission for Administrative Justice, which deals with cases of people saying government has been delaying and government takes long in dealing with the issues of Mwananchi. He should actually be, happy that this one has been dealt with quickly. The real issue though, efficiency, whatnot. But I think on this issue, Chair, now seriously, the contention is not on the legality. The contention really is on what that speed imputes or what it might be pointing towards. And I think that point has been noted. We should not dwell on that too much. The only other clarification we need to give really is on the issue of the seeming contradiction, which does not exist, because if you look at 230, it says in addition to that paragraph, 220, is it 229 or 227, is specific, is general about normal petitions. But it says when there's a specific petition for the removal of office, then now these provisions take primacy over the other ones. So whether it is 14 days or 60 days, I think it is clear. When it's a petition to remove, it is then those 14 days, Chair. From where I sit as a member, I think I have noted the concern. And I think the Auditor General is well within his right as a Kenyan to air that concern. He is concerned that it seems that there's some malice behind it being fast-tracked. Others might see it as efficiency, but we have noted it, and I think we should go to the subject matter.
So thank you very much. I think also on the question of the standing orders.
I think, Chair, what the lawyer is talking about, and of course there have been precedents, is this apparent appearance that the petition is being processed at the speed of light. It's a concern, because precedents have been there, and really it's we are talking about the Auditor General of the Republic of Kenya, and of course I would want to bog down the process, but it is something that really ought to be noted, because there was 7 days to do it, and clearly if it is done within a day, that raises suspicion.
Other members, let's move forward. That on the question of standing order, I think there is no contradiction on the standing order, because there are two sets of petitions. There are the general petitions, and what I would call the constitutional petitions, which is actually for removal of office holders, which is very specific under 230. And even when you say 233, it talks about every petition presented or reported pursuant to this standing order, which is actually, the heading is petition for removal of a member of a constitutional commission. So there is no contradiction. The 14 days is for the removal of public officers under constitutional office holders. But of course, there is also a procedure where if we found time and time is not sufficient, there is also a procedure for requesting for additional time. So I don't know whether you are okay now. We proceed.
I'm happy to continue, Mr. Chairman. So the logical question that arises from that question of efficiency, if you wish, in processing the petition is, as the legal counsel says, is there anything adversely that comes to affect the respondents as a result? The answer is yes, and we've detailed it, and it is one. That for that reason, a petition that is clearly inadmissible for failing to comply with mandatory requirements of the standing order and of the Parliamentary Petitions Act was admitted and is now before you. I will not go into the details, but I'll just point you to where that is demonstrated. On page 1, Mr. Chairman, Roman 4, we have demonstrated that in terms of what, therefore, the persons concerned would have considered, not just the standing orders, not just the Parliamentary Petitions Act, but also the Fair Administrative Action Act. It is in page 2, Roman 5, you will see that the petitioner claims in the petition that is one of the petitioners. The standing orders require, both the Act, Section 3I, and Standing Order number 223I, that all the petitioners must indicate their names, they must sign, they must put their thumbprints. Here, one person is saying, I'm one of many. No one asking who are the others. Number 6, the standing orders number 223 F, G, and H are very clear, and it is for a good reason. When you present a petition, this committee and Parliament is not supposed to act in vain. The standing orders and the Act require you to state, have you presented these matters to court? If so, which court? What was the outcome? Have you presented before any other competent body? If so, which one was it? What was the outcome? That is why the discretion in terms of removal from office is now invited, that you may be required to provide evidence, because to consider this, you do not want to be considering something in parallel that is going on in court. And the assumption then is, if somebody presents such a petition, then you ask them, let us see the proceedings. Is there any judgment? Let us see it. And then you determine at the clerk level, at the advisory committee, is it authoritative or not? That was not done here, with the result that the petitioner is speaking from the air, saying, these are the matters I presented in court. No one has those pleadings, because that was not examined. Mr. Chairman, that is why the reason in page 3, Roman 10, under 251, and it is very specific, and the case of Wambora in the Court of Appeal is clear on this, you do not just seek to remove somebody from office for breach of the Constitution or misconduct. It has to be a serious violation of the Constitution, and it has to be gross misconduct. And the case of Wambora, and I've attached it.
So do I now say that you are now prosecuting the issues? No, I'm also the chair. I'm supposed to guide the. Order.
The chair, you also have to listen.
Order.
You represent the committee, and you need to be fair. The chair cannot decide to act for the committee in the way that he wants to do. Allow them. Why can't you allow the decision to go through?
Order. I'm just clarifying from him whether now he's already prosecuting the issues. Yeah? So that then we then decide on the procedure of moving forward, because initially you are raising those preliminary issues. Now you have said you are taking us on for you to make a decision you must have serious violation. Those are things which are decided after now the issues have come. The committee goes and sits and decides whether they are serious violation or not. Yeah. So I'm just asking you whether do we now proceed to prosecute the issues, or you are still you are still poking, you are still on the admissibility of the petition.
Mr. Chairman, I understood you to guide, as we had agreed, that first you will allow me to raise the legal objections as fast as I can. Then once we are done with that, we will come to the factual responses to the petition. I am doing what I can to respond as quickly on the legal issues. And the one that I'm covering at that point is one. That, and it's the question raised by the legal counsel, what prejudice does the respondent suffer for the fast tracking of the petition? And that's what I'm demonstrating. That had they done it diligently within the time that was allowed, they would not have admitted an inadmissible petition. And the point I'm making now, which is clear in that decision of Wambora on page 54, is that if somebody presents a petition to Parliament, you can't just allege that you violated the Constitution or you misconducted yourself. You must say it is a serious violation, and the standards are clear. In the Wambora case, I can come back to that later. You must say there's gross misconduct, and then you demonstrate. That is why there are 3 preliminary processes before 29 honorable members are put to look at a matter which therefore may not have been admissible in the first place. So the point I was making, and I'm only pointing out very quickly without running through it, is that the petition, to the extent that it does not even allege a serious violation, forget about the facts, it does not allege gross misconduct, because that is the standard in Article 251. Then, if it had been looked at carefully, it would have been inadmissible and rejected at that point. But even though it was not, I'm seeking to persuade you that as a committee, you are empowered to look at the admissibility before you come to the facts. And you might actually dismiss it because it was not admissible in the first place. And I just had 2 more to finish.
This petition is rightly before this committee. This committee does not have the competence to overrule the Speaker for having committed the petition to us. We can only note the point that he is raising, but to determine whether it was admissible or not, it is as if the office of the Speaker would have done what he has asked this committee to do, so that it would say, no, there is not sufficient evidence to consider this. That would have denied the people of Kenya to give their responses to the allegations by this particular petitioner. As much as there are insinuations of something was being rushed because of some interests, we are aware a number of people accuse us. This is a government of cartels, by cartels for cartels. But the petition is rightly before us. Let him make his points. We don't have the capacity to reject what the Speaker has committed to us, but we have reason to go through the evidence submitted by the petitioner, the response by the officer, and we'll take note of any of those items and make our recommendations. The issue of whether it is gross violation or serious will be the substance of our own report. So he can help us by pointing out how each of the allegations in no way is serious violation of the law or the Constitution, or is any gross misconduct or any abuse, then allow us to proceed.
Thank you. Thank you.
I
think that Dalmas has raised a very important question. That you know, you cannot say the speaker will sit and determine whether there was gross violation and therefore determine. That is the work of this committee. Yeah, and that is why we have called for submission of memoranda. We have called you to come and respond to the issues. So surely,
Speaker, let me just help you. Yes. The work of this committee is to determine if the petition discloses
serious grounds,
enough grounds for the constitution of a tribunal. To consider. It is the tribunal that will determine gross violation, serious violation, and so on. Yeah. Ours is whether there are sufficient grounds to proceed to the next step.
I think you are well spoken.
But that is a kangaroo.
So other members, and I think
kangaroo tribunal by the president who wants to remove him.
Order. That is the constitutional.
Point of order, Chair. Point of order.
Yes, okay.
Honorable Buru Odinga needs to withdraw his remarks and apologize or remove himself from this meeting, because I think you should be happy not to hear, because the allegation, Chair, we don't even have to repeat the allegation.
Repeat, because I didn't hear. I'm sitting next to him.
He will repeat something else. Listen to my inspiration, then you will.
Let me.
This is a kangaroo tribunal set up. Can you clarify?
Mr. Chairman,
because we also have a Hansard.
Can you apologize? You have such which he hasn't said.
Order members. Sakaja order.
I think then you apologize.
Order members.
Chair, if you didn't hear, I will commit my request to the Hansard.
Okay.
And at the point when they can use what say, then you'll have to take that action. Because I'm
Order members. Order Oburu. Order Oburu. The chair has not said anything.
But why do you allow Sakaja?
Let's proceed.
Yeah.
Let's proceed.
Why do you allow?
Let's proceed.
But Chair, I have put a request.
Let's proceed. Sakaja, relax.
Chair, no, I'm not relaxing. Chair, I have put a request to you. The Hansard recording, 3:56 p.m. to note 4:56 p.m. to note if whether what I am saying that has been said by the very Honorable Oburu Odinga about a kangaroo tribunal set up by the President is there. The answer will tell us. There's no need to debate it anymore. If you didn't hear it, you didn't hear it. No. But I put a request, because you cannot allow such snide remarks. You cannot allow such snide in such a process.
Order members.
Yeah.
Mr. Chairman,
order members.
This is a flabbergasted tactic.
Chairman, I think what the standing orders require is only substantiation. If you make an allegation, you must substantiate, and you cannot just withdraw
did you make the allegation?
Yes, I did. I said that the kangaroo court to be set by the President, who wants to remove kangaroo court. Tribunal, which wants to remove the holder of AG's office from office. And I say this, Mr. Chairman, because if you will recall, Mr. Chairman, when there was a delegation in the State House, you remember when the President was so furious.
You are out of order. You are out of order.
This man wants.
You are out of order.
This one wants to go to America.
You are out of order, Oburu.
He's bringing other matters to this committee.
You are out of order. You are out of order,
Oburu. To this committee. Chair, he's bringing other matters to this committee.
Order. Chair. Members, Chair. Order.
Chair, you cannot possibly take those statements lightly.
Order members.
Chair, you cannot possibly take those statements lightly. You can't. He has accepted and has even added salt to injury.
Order, Sakaja.
Honestly, Chair.
Order.
We are also friends to this committee.
Order members.
Chair, just a minute, Chair.
Yes.
We've just come to listen to a very serious petition. And Chair, in my view, you're the Chair. You need to take control of your committee. And such allegations which have just been accepted by Honorable Oburu Odinga, and you just allow him, and he's not withdrawing, and he continues again to even put it. I mean, Chair, we just plead with you to control of your committee so that we can be able to move on. And where people are making to withdraw.
Oburu, please withdraw those comments.
He's a new member, Mr. Chairman. He doesn't know that.
Order.
Oburu. It is only substantiation which was required.
Oburu, Oginga, please.
They are laws.
You are not above the committee. You cannot just dictate to us what we need to do here. You also need to listen to us.
But you
cannot just be dictated. You are not the chair.
You have standing orders. Keep to the law.
Order. Oburu, you are a senior. You are. Please,
I beg your pardon, Chair. I beg your pardon, Chair. You know, Chair, as I listened, I thought Chair did not hear what Honorable Oburu made, but he made it worse by accepting that he said things. Now, my issue, my issue is when we withdraw or we apologize here, we only withdraw or apologize to what is unparliamentary. There is nothing unparliamentary about a kangaroo court. A kangaroo court is just a court which is not done within the system. I want to understand what it is that is withdrawing. What is it that is withdrawing from? A kangaroo court is a normal English word.
Chair, what is improper is the insinuation that that kangaroo court or tribunal is being set up maliciously by the president, and you're putting improper motive on the president that you want to remove him for whatever reasons. You conduct of president, discussing the conduct of the president according to our standing orders, and you sit on the speaker's panel. You know very well the procedure through. Oh, you also. Oh, fortunately, he was thrown out. But you understand the rules. To impute improper motive on the president or to discuss the conduct of the president requires a substantive motion in the House. You cannot base it on a snide remark, as off-cuff, and you just accept it that the president is setting up a kangaroo. This is a petition by a Kenyan. We're listening to the merits and demerits. It might as well be frivolous. We will throw it out. If it has grounds, we'll set up the tribunal.
So, order members.
The more you bring side to you even make discussion.
Order members.
Mr. Chairman, I withdraw. I withdraw.
And apologize.
And apologize, please.
Well, it's not an apology. You withdraw and apologize.
So, members, let's move on. Let's move on. I think, members, let's move on. Let's move on. Let's move on. So,
Chair,
I think
just on what the gross violation. You remember when there was a cabinet secretary, and people collected signatures in Parliament, and then they were withdrawn, and the Speaker gave a very substantive ruling regarding gross violation and things like that. And he made it very clear what is gross violation of the Constitution and things like that. And he said from now henceforth, any petition for removal of a cabinet secretary or a constitutional office holder must meet this requirement. So when he has appended his signature to this petition, it is my belief that then that petition must have attained those standards. So again, the aspect of, and I agree with Dalmas, as far as we are concerned, ours is to look at the merits, and then we leave it. And if we agree, we say.
So members, let's move on. I think Wakili, with due respect, the merits of the petition is up to this committee to determine after hearing both sides as to whether there were gross violation or not violation. The petitioner has made this case. You now have the opportunity to respond and deny, and that is up to the committee to look at in the balance of things, whether there are merits or no merits in the case. So I would really say we save time by moving to the issues, so that then we move to the next phase.
Thank you, Chairman. There are only two more issues that we'll invite the committee to consider. Mr. Chairman, I invite you to consider paragraph 37 of the petition. And this is what the petitioner says: that despite the fact that the matters raised in this petition have previously been addressed by the Ethics and Anti-Corruption Commission and Office of the Director of Public Prosecution, the responses given by both offices have been unsatisfactory. The petitioner is telling you that he went through the constitutional process of the criminal process. That process culminated in the Director of Public Prosecution dismissing the allegations against the Auditor General. The entire report is annexed to this petition, and you'll have time to go through it from page 19, page 20. Yes. From page 20 up to page 20, up to page anyway, up to page 24. It is a detailed report. The Director of Public Prosecution, in terms of his constitutional jurisdiction in Article 157, concluded that the complaints that now are being brought before you, as presented against the Auditor General, had no basis. The petitioner is telling you he is not happy or satisfied with the conclusion by the Director of Public Prosecution. The question is this: is this committee competent to entertain an appeal against the decision of the Director of Public Prosecution in contravention of Article 157.10? I will leave it as a question. Our submission is that this committee must guard against abuse of the parliamentary process by persons who are not satisfied with other constitutional processes now coming before you. If one is unsatisfied with the decisions of the DPP, the law is clear what you do. If one is unsatisfied with the decision of the High Court or the Court of Appeal or the Supreme Court, the law is clear what you do. You do not run to Parliament because you are dissatisfied. To that extent, the entire petition with this admission is missed. The last point is this, Mr. Chairman. Standing Order number 89 raises the question of sub-judice. And Standing Order number 89 defines sub-judice in a very interesting manner. It, in 89.2, it includes active criminal or civil proceedings. With all the materials that the petition has placed before you, there is an active civil and criminal proceedings. By his own admission, he says these are the matters he took to court. He has not produced those documents, and I imagine he will produce them. But he has admitted that these are the same matters he took to court. How then does he escape Standing Order number 89 in terms of the rules of sub-judice? 89.3b goes even further, and C. And to that extent, therefore, Mr. Chairman, a petitioner who admits that he has exhausted the criminal processes, a competent body has made a decision, he has gone to court, he is not satisfied with the court, or the matter is pending, cannot come before you. And the substantive matters that he's inviting you to look at are clearly matters he's unable to prosecute before the relevant bodies. Is it right for this committee to assume the powers of the DPP or of the court? I have summarized that, Mr. Chairman, but we have laid them out in detail in terms of our response. With your permission, I now wish to invite the Auditor General to come to Part D of the response, which now addresses the specific allegations.
Yeah, so I also maybe to just make a comment on that so that it doesn't appear like you put your points and we don't have. I'm sure you also agree with me that whatever criminal proceedings were only in respect of the IEBC system, but you also agree with me that the petition as it is on that and other questions, including non-filing of reports, including allegations of recruitment, favoritism in recruitment, including misuse of vehicles, So I think as you when you say that, you should appreciate that the petition covers far much other things. Of course, in addition to that, whatever you are saying is in court.
Mr. Chairman.
Yeah.
Mr. Chairman, you will remember I raised this in the morning.
Yes.
That we need to review the court proceedings, and the petitioner did respond that the court proceedings were only specific to the vault,
yes,
the procurement of the vault. Now that the respondent has raised that matter, we would need to decide as a committee whether that issue is thrown out and not considered by us, so that we only consider the other issues which have now been brought together with the petition. But the issue of the vault, which has been handled by the court as he admitted it was specific to that, which has also been handled by the DPP, should not be brought before us. We should look at the other allegations in the petition, and which one of them remains serious enough after the vault is declared not admissible before our proceedings. If it was in court, he should have petitioned. He should have appealed in court, because he admitted he took a specific matter of the vault to the court. If it is about the DPP, he should have had other recourse on how do you appeal on what has been raised by the DPP. So we will decide when we were considering this matter, whether that issue in the petition will have to be disregarded by us because of the manner in which it has been already been considered by other.
I think you have made your point, Dalmas. Let's listen to Sakaja, and then I'll come to Oburu.
Chair, I want to concur on one matter and just seek further clarification from Council. One, from the annex that he has pointed us to, the only matter that is alleged to have gone through to the DPP's office is the issue of audit vault. And so that does not mean the other matters were taken to court. Number two, is even that matter still active? You know, you've read to us yourself 89 3B, that criminal proceedings shall be deemed to have ceased to be active when they're concluded by verdict and sentence or discontinuance. Is it still continuing? Is it a matter that is going on? You know, and finally, Chair, even if the matter is concluded, a court process had a different outcome. This petition is not for sentencing or verdict or or whatever on the Auditor General. This is a process of removal from office. The court process is not a process for removal for office. You know, those are two different processes. So I think with those clarifications, we can choose whether to you know, lift the issue of audit vault and not look at it, or even look at it in its entirety. If according to this letter, the DPP threw it out. So if the DPP threw it out, it means it is not active, meaning that the provisions on sub-judice do not apply. And even if it was, then that is a process of sentencing of, on Chapter 6 or whatever economic issues, not a process of removal from office. They're two different processes.
Sakaja, you have made your point. I think you need to...
No, he has made a bad point, Mr. Chairman.
You have made... But the point is...
He's trying to rely on sub-judice.
No, we want to find out.
Order.
So you can raise it again for removal.
Dalmas.
You're not understanding, Dalmas.
Dalmas, I said he has made his point.
A bad one.
Yeah? He could have made a good point, but his point. You can also make your point.
Agreed.
Yeah?
I think my point is very nice. His is the bad one.
So I think what you need to know, Wakili, is whether there is even a case in court on this matter. Whether was there a case, or because the way I see myself, the documents I have, it's like there was some investigations by the DPP, and somehow it disagreed on some of the allegations. Yeah. So was there a case? Because if it is with the DPP, then that's not a court. Yeah. The only sub-judice we are talking about is when it is in court, and of course there are standards of measuring that sub-judice. Yes, Shakir.
Thank you, Mr. Chair.
Okay, I will come to you.
Thank you, Mr.
I'll come
Chair.
to you.
Thank
I will
you,
come
Mr.
to you.
Chair.
I'll come to you.
Mr. Chair, thank you. I just now, as they presented, Mr. Chair, as they presented number 5.
Order.
as he presented number 5, the legal counsel, he said it's instructive to note that there is only one petitioner demonstrated in paragraph 2 of the petition affidavit. There seems to be more. Can you show us where the petition mentions more than the petitioner himself? He says in the affidavit, paragraph 2, which I then looked at, it says that I am one of the petitioners to the petition. So I wanted guidance, whether is he right in saying this, and is the affidavit overrides the petition? Because in the petition he says I am the petitioner, but in the affidavit he says he's one of the I, the undersigned petitioner. No, I was just a clarification, Mr. Chair. From
that is, you know, Shakir, when you raise the same point which has been raised by the, I mean, we are just repeating ourselves.
Chair,
I understand that point has been raised by the lawyer himself. So when you raise again, you are repeating yourself.
Is Dr. Oburu in order? He's saying because of his color, he's getting it.
No, I didn't say
that.
I didn't say that. Now,
Oburu, today you are...
No, I didn't say that. I didn't say that, Mr. Chairman. He's misquoting me. He's misquoting me, Mr. Chairman, and I don't like that. Now, he needs to apologize to me. I'm not saying... No,
let's move on. Let's move on.
Mr. Chairman, what I'm raising, you know, what we were told here was that the case before the court was only about the vault. But, Mr. Chairman, in the written petition, which is sworn here, this man said in number 37 that despite the fact that the matters raised in this petition have previously been addressed by the Ethics and Anti-Corruption Commission and the Office of the Director of Public Prosecutions, the responses given by both officers have been unsatisfactory. Mr. Chairman, it is in respect of all the issues. But then, how do we now say that he was only, that the case before the court was only one, and yet the signed one, which he has given us here, says, in respect of all the issues he's canvassing here, he has presented them there, and they have been unsatisfactorily handled.
Mr. Chairman, certainly I tend to agree that this petitioner is attempting to use Parliament as an appeal institution instead of going to the original institutions that have jurisdiction to take care of the complaints that he is raising. That 37 spoils his own case. I was trying to argue that it was about the vault because that is what he told us. But he is admitting in 37 that other than the vault, all these issues had been reported to EACC. And the EACC came to the conclusion.
Other members.
Yes.
Let me just also, let me inform you that it is a requirement, and it does not in any way, to me, make it wrong. Because it is a requirement. If you look at the 223, the form of the petition, if you look at it, says, a petition shall be in the form set out in the task schedule and shall A, B, among other things, and then it talks about F, which says, indicate whether any efforts have been made to have the matter addressed by the relevant body, and whether there has been any response from that body, or whether the response has been unsatisfactory. So it is actually correct the way it has come in the petition, that you must indicate in your petition whether you have had the matter taken to the relevant competent body, and indicate whether there was any response and whether the response has been unsatisfactory. And that's exactly what the petitioner has done. He has said, I have taken the matter to EACC, and the response was unsatisfactory. That's according to our standing orders. As to now whether now the question of sub-judice, I think unless there was a court case, which he will convince us, but as to whether now the committee can deal with the matter which EACC has dealt with, that's another question altogether. But as if you want to use that as you know, to say the petition is admissible to the extent that it has been taken to EACC and then the responsible admissible, I think if you look at that standing order, it clarifies that
Mr. Chairman,
that is how it should come.
You are reading that standing order out of context.
No.
Because what was taken to the other courts, that standing order applies to all petitions.
Yes.
But the matter of removal, right, is only in this petition. So if we apply that standing order, he could not have sent the matter of removal to any other agency. But now he's using what other agencies have disposed of as incompetent and not acceptable to apply for removal. So we need to make a decision in this committee whether that application...
Which then I'm saying...
Yes.
Where we are now.
Yes.
Yeah? Where we are now, because we have to listen to the Auditor General. There'll be an session for the committee to make decisions now. Yeah? To make decisions and say, unless you want to tell me which part of the law we say is, if I've reported the matter to EACC, then it should not come to Parliament again.
Chair, our standing orders are very clear.
Yeah.
Because sub-judice is a very serious issue. And that is why the standing orders say the following two things, and I'll say very quickly. It says that a matter shall be considered sub-judice when it refers to active criminal or civil proceedings that is in court, and the discussion of such matter is likely to prejudice the fair determination of that matter. It then goes on to say in 89.4 that a member who is alleging, because there must be, you know, the person where the evidence must come from, a member who is alleging that a matter is sub-judice shall provide evidence to show that paragraphs 2 and 3, and 3 is that criminal proceedings are active and are not concluded by a verdict, by a sentence, or by discontinuance is there. So, Chair, it's a very simple provision. We must be shown if there is an active criminal proceeding in court, then there must be evidence brought to say this matter that you're discussing currently is in court. And it is discussion. Being in court is not enough. And the fact that you're discussing the matter will prejudice the fair determination of the court case. That is how sub-judice, and I'm sure the legal counsel will agree with me.
Point of order, Chair. Point of order.
Yes, Chairman.
Chair, I am not a lawyer really, but I think, Chair, if you look at the wording, I really would wish to be advised by our legal counsel on the wording of this 37, that despite the fact that the matters raised in the petition have previously been addressed by the ethics. Chair, if you look at that statement in totality, isn't the petitioner then simply saying that Parliament, as a prosecuting body, is now replacing the office of the Director of Public Prosecutions? Parliament, as an investigative body, is replacing the Ethics and Anti-Corruption Commission. Wouldn't we then, Chair, be saying that Parliament is actually disregarding a constitutional office, which is the office of the Director of Public Prosecutions? I really would wish to be advised by our legal office what this.
So I don't know what is the argument about here.
Let me give you the argument, Mr. Chairman. A petition
let's listen
for
to
removal.
Yes.
A petition for removal is for gross violation of the law or the Constitution, where a concluded case process has dismissed that there was no violation of the law. You cannot now again present the same issue. There is no sub-judice issue on this one. The issue is what went through the courts and the DPP were allegations whether there was any criminal activity that the DPP should prosecute, or what was taken to court, he should have been convicted. Now, once those two have been dismissed by the court and the DPP, you cannot use the same evidence for removal, which is for violation of the law, and the competent organs have said there was no violation of any law.
Even as we spend our energies on those, you should quote the relevant legal positions. Let's listen to Moita.
Chairman, I want to assist the committee. In the interest of time, you had ruled we proceed. From the look of it, we seem to be on the side shows, and maybe members are taking advantage of free air time in the telly.
Other members, other members, let's listen to the legal counsel, Parliament. On that matter, do you have anything to say on what you have been canvassing? But where I sit, members, so that we proceed. Where I sit, I think it was just 37 was just meant for disclosure, because under the general requirement of for presentation of petitions, it is a requirement that you disclose whether these matters have been handled in another quarter and whether you are satisfied or not. And then it is for this committee now to determine whether we proceed or not. Yeah.
Chair.
So let's listen to.
Chair. Just a minute.
Please, please.
Honorable Sakaja alluded to a very important thing. Just to be told under 89, the sub-judice, whether to get some clarification, whether it is just that. And secondly, when a member requests the legal counsel to give an advice, is it right for another member?
Chair, 1 minute, Chair. I don't know.
Other members, let's proceed. You guys, you are just.
Chair.
Mr. Chairman, can you be in charge of this meeting?
Other members.
Mr. Chairman, can I say this?
Would you be in charge of this meeting, Mr. Chairman?
Members, order.
You know, Mr. Chairman.
Order, Mheshimiwa. I think let's move on. Let's move on. Let's move on. Thank you.
I just wanted to say that when we interfere with the subjects, it also constitutes to us denying them the opportunity to be heard. Let us hear these people uninterrupted until they finish everything, and then we can say everything we want, so that they get their time.
So then let's move then as follows, Auditor General. There was, and so that we give you an opportunity to respond to issues without leaving some. And this is what we decided in the morning, that we'll be very systematic. We'll go allegation by allegation. You respond and say there is no merit in that, or there is merit. Then we move on. So, for example, there's allegation on reporting to the Parliament and the Presidency. Yeah.
Okay, thank you, Chair. I think my council has raised my concerns, and those were my concerns because that's where I saw the unfairness of the whole process. But what we are doing is for it to be in record, and which I believe you've taken it on record. Now, let's go to Part B, which is the substantive response of mine. And I refer you to, no, I think it's page 10. Yeah, so I refer you to the report from page 10. Are we all there? Page 10. Now, and you also should have the petitioners, because we will try to the extent possible respond to point by point, just as you had, I was requested, or you have requested me. The petitioner point 1 is just a statement, so I didn't respond to that. So I'm responding now to 2, 3, 4, and 5. Are we there? So the answer I'm giving is responding to 2, 3, 4, and 5. And I will basically read in that response to those issues. I believe there is no obligation of the Office of the Auditor General, which I'll say OAG, to submit an audit report to the President. But in accordance with the 2297 of the Constitution, I dutifully submitted all reports to Parliament as mandated. That's our audit report. I believe the report which is contemplated in 2541 is really not an audit report, the types which I do under 229. This is a report, and let me refer why I'm going to say, if you look at Article 251, the Constitution provides that as soon as practicable, after end of each financial year end, mark that word and underline, each financial year end, then blah, 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 each commission will, okay? I do submit financial report each year end. And that report has necessarily to be an audited report by the auditor which is appointed by this parliament. So that report can only be submitted once it has been audited. Now, to the extent the auditor has not audited the report, I cannot myself write that report. So that financial report has been dutifully submitted for the years 11-12, 12-13, and 13-14. And that's also further in accordance with Article 2264 of the Constitution. I think I've alluded to that, so let me not read that again. And we have received a letter from the auditors, which we marked there and copied, which attached A1 is there. So let's you look at that. So those are my response to 2, 3, 4, and 5. Now, in response, again, let us take off, as I say, you take off the ones which I've responded to, and I'm taking them off also. Now we go to paragraph 6 of the petitioner. I'm responding to paragraph 6 of the petitioner. Then you go to paragraph 28 of the petitioner. You take that. Paragraph 29 of the petitioner, paragraph 30 of the petitioner, paragraph 31, paragraph 33, and paragraph 34. So let us take those out. Let us take all those because I'm responding to those in this bit. The review of internal control systems of the Office of the Auditor General was not part of the scope of the auditors appointed by the audit by the Parliament. The auditor is called BTM. And I believe there is no conflict of interest to the extent that BTM I requested them to review the systems. And I would like the view of ISPAC to be sought on this because they're the professionally appointed body to pronounce itself on whether there was a conflict of interest or not. And they did actually pronounce themselves. You got that? That's ISPAC. Oh, incidentally, they've already they wrote back on page 76. We have ISPAC view on that, and apparently they say there's no conflict of interest. And furthermore, because it is the auditor appointed by the Parliament, before I did that, I wrote to the clerk to seek approval before I gave that work. And that I refer you to the exhibit marks A2, page 21, right? No, it's okay, they'll go through it. In response to, I'm continuing in response now to number 7, paragraph 7. So in fact, this response covered a lot of issues, which I've said. They covered a point, how many? 1, 2, 3, 4, 5, 6, 7, almost 7 points. So we started at 6, now we go back to 7 of the petition.
7 or 6? Maybe
no,
members,
6 already been covered by my answer.
So maybe members, other members, maybe the way we are proceeding in the morning, maybe we should apply the same, so that we don't lose track. Because what we did in the morning was, when the petitioner said allegation by allegation, we ask questions, Then we move to the so because where I see now you have given us your response on 1 and then number 2. Yeah, you have given us on allegation 1 on failure to submit reports. You have responded to that. Then number 2 on the appointment of the auditor. Now you want to go to 7, which is another allegation.
I've responded to 2, 3, 4, and 5.
Yes. So now, maybe members, we should, if we have questions on 1, that is failure to submit reports to the president on the basis of what the Auditor General has responded. Do any member have a question on that? He has said, of course, you have seen his response that 1, 2, there is no obligation of the Office of Auditor General to submit an audit report to the President. Then number 2, in accordance to Article 229(7) of the Constitution, the respondent has dutifully submitted all audit reports. Then number 3, the report contemplated by Article 2541 is not the audit report, but is a report containing financial accounts of. Yeah. So let me hear. So take notes on the questions on that, and then you can clarify. Honorable Sakaja.
Chair, thank you. This response by the Auditor General that there is no obligation on the Office of the Auditor General to submit an audit report to the President, I agree completely with the Auditor General on that one. The Auditor General gives audit reports to Parliament and those other reports. There's a report contemplated in 2541, which in my own reading is not an audit report, neither is it a financial report. Really is a report on the state of the institution. You know, the same way you'd get one from all other independent offices. And the fact that there is lack of clarity, I think the committee should probe whether other independent offices have been submitting any report annually to Parliament or to the Presidency. Or what we can ask the Auditor General directly is, have you received any guidance from either the Presidency or Parliament on the kind of report contemplated? Because the provision on the Constitution is within the chapter of how commissions operate. And it says that as soon as it's practicable, at the end of each financial year, of course, him being an accountant, picked out financial year to mean a financial report. I think the CIOC was giving a different type of report, probably not a financial report. The commission, this Nyachai Commission, was giving another type of report on the state of the institution. Do you feel that there is lack of clarity amongst either your commission and other independent commissions on what specific report is envisaged here? Because on the response of where you're saying there's no obligation to submit audit report, I agree with you completely. Audit reports are submitted to Parliament, and those ones you have been submitting. So that ground I don't think holds any water. But generally, moving forward with other institutions, do you think there is enough clarity on the manner, on the type of report, and the form of report that should be submitted? Because then that means that this provision then is being flouted by all other independent offices that we have in Kenya.
Okay, just take note. So then, member for Ruarak.
On the same issue, but probably I should ask your lawyer to be fair to you. If you look at 254, the way it is worded, paragraph 1 and paragraph 2, 1 says as soon as practical, within that financial year there should be a report. Then 2 says at any time the President or the National Assembly may ask the Commission to give a report. What was the intention of the drafters here? In other words, if the Commission fails to give a report, shouldn't it be conversed that even the Assembly or the President may also request that report? In other words, it goes both ways. What is your response on it? And so that failure to it, would it constitute gross violation of the Constitution? That's what I'm heading at.
Any other member interested?
Okay.
So, okay, Auditor.
I think you're asking me to imagine what was contemplated in the Constitution when they say report. What I believe was contemplated for, say, an institution like a commission would be when I have audited them, I've given them a report, Then they will add other issues, to understand, which they may consider relevant, but it has to go with the financial report according to 254, because it talks about financial year-end. That's what my interpretation, and that's the interpretation I've adopted for myself. Now, indeed, if you look at the audited report which comes to the Parliament, it has other issues. It will give you the management, it will give you the budget which we had, and what the total, and other things. Then it has the financial statements, and that's the report which I believe is referred to each, and it talks of each year.
You see, that is a problem that I believe.
Yeah.
So what I was asking was, do you feel there's clarity amongst all independent
there is no clarity, and there's no guidance. This is my interpretation. There's no guidance.
This is your interpretation.
Yeah, there's no clarity. There's no guidance.
So
that's important for the committee.
You know, members, that 254 says that there is need for independent officers to file a report with the President and Parliament. So do you issue the same, because you seem to say the one you send to Parliament has other information, so do we send again to the President?
There are different reports, Chair. The 1 on 229 is the audit report.
I'm not, in fact, the question you are addressing in this sitting is 254, not 229. Nobody.
Yes. Mr. Chairman, you remember I raised this in the morning, that 254, 1, 2, and 3 needed further legislation to guide the application of those clauses. The reason I was saying so is really what was contemplated when we were doing the Constitution. In addition to the financial reports, the President needs a brief of the operations of every independent commission.
Exactly.
Though they are supervised by National Assembly to where the reports come and other issues are raised, but we felt that at least the President should get a package informing him of what is going on under every independent commission. Really, independent commissions are also part of the executive and is the head of the executive, but they were constituted independent for better governance arrangements. So some reporting was required, but we never have given legislation to guide the content of such reports that should go to the President.
So that was and I think the Auditor General should also come out very clearly. Because Akaja has asked, do you think
there is clarity?
There is clarity, which I believe you should take an opportunity also to say, if there is no clarity, the way everybody agrees that there is some confusion whether is it financial report, is it what kind of a report? You know, there is no structure of the report under 254.
Because it is clear, you know, from my reading, it is clearly not a financial report. You know, because your audit is appointed, the auditor is appointed by Parliament, and the audit is done, it becomes public domain. And in 2543, it says every report shall be published and publicized. The report of the organization, how has it been faring on? You have hired these people, you're now moving into the counties, etc. That is what was envisaged. The one in 2542 is on a particular issue. And I'll give you two examples. One example is when the President asked for a report from EACC on who they were investigating before the State of the Nation address in 2015. That was a report under 2542. Or when a committee of Parliament that is investigating a matter asks the Auditor General, kindly give us a report on the operations of KICC, for instance, or Rongo constituency. When you ask for a specific report on Rongo constituency, that is a 2542. So, Chair, in my opinion, there's no ground on that 2542.
Yeah, that's why I asked Chair, the lawyer to respond. That failure to provide a report on 254, would that be a ground to constitute gross violation of the Constitution?
I don't know whether other members, I think that decision is actually the decision of the committee. So it's not, you know. So members, okay. Members, let's move to the next. If there are no other questions on the reporting, but I believe also maybe I take the opportunity because of the presence of the former ombudsman in the House. Of course, you are here on another, but you must also have faced with this 254 in your former position. What kind of report? What? Yeah.
He resigned.
So did you also find a problem under 254 because it was affecting all the independent officers and commissions?
Chair, I think I can respond briefly because I also had the advantage of sitting in the committee of experts. But I think, yes, and as a Commission on Administrative Justice, we dutifully submitted those reports. But there's one important distinction with this office. As I understand it, the first has been made by honorable members. The legislation to activate this has not been done. But the second, for all other commissions, the most important aspect of that report was always the audited report. In fact, without it, no commission would submit a report. In the case of the Auditor General, the person to audit him is not him. It is under 226, a person appointed by Parliament, who then has an independent obligation to report on it. That's what Article 2264 says. The reporting does not fall for him. And that is why, in my view, in terms of this annual report, for commissions, it might be more fundamental because it's the only way you get to know the audited accounts of the commission. For the Auditor General, I think the primary obligation is the person you appoint to audit him, and that is not his obligation. That's my understanding.
So, other members. So, are you in any way trying to say also that the person appointed to audit the Auditor General did not do his job on time, and they have no, because even when you appoint an auditor, there are also timelines. I'm also a former auditor, so so are you saying the person appointed to audit your office did not submit audit reports on time, and therefore you are unable to?
Is sitting more appointed was Parliament. Parliament. Therefore, that person was to report to Parliament.
The question you're asking me actually should ask the clerk, because the Parliament appoints the external auditor for me. To the extent they haven't appointed to the auditor for me, I cannot present a report. So the lateness is due partly because it is not me who appoints the auditors. And even right now, I have not submitted 1415 because Parliament has not appointed the auditor.
Chairman, the report...
Which audit do you have?
Chairman.
What is your latest audit?
Last one is, as we said here, is 1314. After that, Parliament, I've written 10 times, many times.
And so if 1314 is complete,
yeah,
and you're saying this is a financial audit report,
financial
have you submitted a report to the President and Parliament based on 1314?
There is neither, like the Honourable asked, whether there is a response. Nobody has asked or requested a report, and they don't even know which form of report they would have wanted. But also, one has to be careful when you talk about the Office of the Auditor General, because the President is essentially my client, and if at all is the one to decide on the contents of my report, we don't know what he might put in that contents of report. So I think for the Office of the Auditor General, I think these are some of the things which has to be regulated by law.
In as much as the law needs to clarify it, I think when it says that actually all commissions, each whole of independent office shall submit a report to the President and Parliament, it means every institution. There is no institution with any higher mandate than the Presidency, according to our Constitution. According to our Constitution. So it means in whichever form that you get the report, you cannot say that then the Office of the Auditor General cannot submit a report to the Presidency. I think I think that is out
Chairman.
of time. But there is need for that clarity on what kind of a report. But a proactive leader of an independent institution would actually have sought clarity from the relevant offices on what kind of report they require.
Mr. Chairman.
I had earlier dismissed the ground, but now I'm getting convinced.
Mr. Chairman.
Yes,
I want to seek clarification.
Yes, Chimi. Chimi, can you?
Is there anybody?
Other members.
Mr. Chairman.
Let's give Chimi an opportunity to make his maiden speech today.
I made one in the morning.
Oh, sorry.
Anyway, be it as it may, I want to seek clarification that the presidency is a client of the Auditor General. Is there another institution in Kenya which is not his client? And therefore, he doesn't have to report to anybody.
Parliament is also a client of the Auditor General, but we oversight him.
Mr. Chairman, before we finish the item,
yes.
When the Auditor General is audited by an auditor appointed by National Assembly, and that auditor will report to the National Assembly. Up to now, I have not had the majority leader read, even in 2014, 2012, tabling the report on the accounts of the Auditor General. So it looks like the reports that came are still kept with the Speaker and the Clerk and have not been tabled in the House. Just for noting, yes, no, on the audit of the Office of the Auditor General, when the independent auditor we appoint to audit him brings the report to the Speaker or to the Parliamentary Service Commission, that report should be tabled in the House, and I've not heard of one.
So other members, let's.
I'm on point number 6 of the petition.
Let's go to the next.
Chair, I'm just talking about Chairman.
Let's go to
Chairman. I'm on petition number 6. Chair,
yes.
If you allow me. You know what the petitioner is saying is that if you look at number 6, that is on page 2.
I don't know whether you have responded to 6. Did you?
Yes.
Okay.
What I'm saying, if you look at the petitioner is saying, he's saying that yes, Parliament appointed a professional auditor to check on the auditor. But the Auditor General gave him other extra duties works to undertake, which are normally done by somebody else, to a point that he also paid 7.2. I mean, the only maybe some clarification is that what is this extra duty that was given so that it can...
I think it is there on black and white that they were engaged upon commencement of the task. Yeah, the Auditor General also assigned the firm other extra work to review internal control systems, which ordinarily formed part of the external audit assignment, for which external auditor was paid 7,200,000 shillings. And so that is the question which we have. And the petition in the morning seems to have said it looked like, you know, this 7.2 was like an inducement, yeah? An inducement. You even said, I don't know, you need to clarify what was the, maybe it's Parliament to clarify, because what was the amount paid to do the work in the Auditor Generals, so that now we compare with 7.2, because the petitioner was claiming that you paid him more than what was paid by Parliament. So to act like it was like an inducement. Oh. Okay. Okay, Mary.
Chairman, I think it is the Auditor General who pays BTM and not Parliament.
And actually, if you look at the letter, Chair.
Yes.
Chair, who has the floor?
I'm just saying.
The honourable member has been speaking.
Please, yes, Mary, please.
Yeah, may I have the floor? Thank you. Chair, I've seen the letter of engagement which the auditor wrote to Parliament, seeking a no objection for him to engage the same auditor. But the questions the petitioner was raising, why that same auditor who had already been appointed by Parliament to do a different report? And I remember asking, was the same duties given to the same auditor within the same period. I've not seen the letter which Parliament, the one that Parliament appointed these auditors with, but I've seen the one whereby Kenao engaged the same auditor. Couldn't Kenao have appointed a different or requested Parliament to give a different auditor to do internal control review? I think those are some of the clarifications.
So I hope you are taking notes. There's a question of one. My vice chair says it's Parliament who engages the external auditor for you, but it is paid by the Office of the Auditor General. So then that means if that is the case, then you know how much you paid for the job that was given by Parliament. Then now you went ahead to give another job as now Auditor General, which then you proceeded to pay. And again, you confirm to us whether this is true or is an allegation. This 7.2, is it a true position that yes, you paid 7.2, and yes, you also engage him? Of course, I've seen on page 21, no objection, but also subject to, because it says that the Speaker of the Nation has given a no objection to hiring of the services of Bekatili Merali to refute the Kenya National Audit Office data control systems as proposed in your letter. And further goes on to say, however, kindly note that the hiring has no financial implications on our part, and that all the necessary requirements for procurement of such services in such an engagement are fulfilled. So of course, even where everybody says, if you ask me, I want to engage Oburu, I'll say, okay, engage. Don't charge me for what he does for you, but of course, ensure also you follow the process of engaging Oburu. So I think that's what the letter is saying. So confirm all those, because one, the petitioner was here. He claimed three things or four. One, that it looked like this was an inducement. These other works were an inducement for you, for him to cause law on the issues in your office. Two, he also said it was a case of single sourcing. Was there a tender? Was there a what? Then number, yeah, I think those are the issues which came. And then I'll come to you. Yes.
The third one, which you haven't, which you forgot, is conflict of interest, and this is what I'm interested in. A allegation of conflict of interest. Now, when you hired this fellow after you had no objection from National Assembly, were you privy to the payment that he received from National Assembly for whatever he did with the National Assembly? One, but even if you knew, even if you were privy, as an independent commission, was it necessary for you, even in the first place, to have judged what he was paid when you are making a decision on the amount you paid? In other words, if you paid more than National Assembly as an independent commission, was it within your province to make a decision on how much payment, quite independent from whatever National Assembly may have or may not have paid, to establish this conflict of interest?
So, a quick one.
I will come back to you.
It is quicker than what you have said.
Yes.
Are you allowed to appoint any other auditor for any other purposes on your own?
Yes, Auditor General, please.
Yes. Even the internal control review, whatnot. That's the question, right? Do you have the legal ability to hire any other auditor for any other purposes directly?
So Auditor, please clarify on the payment. Was it you as auditor, Office of the Auditor General, who was paying the auditor, or it was the National Assembly paying? And then now go to the 7.2, the extra work.
Thank you, Chairman. The audit is engaged by the Parliament. Parliament pays the bill. I don't pay the bill. As for this extra work, it is normal, the auditor being audited. This is one of the first time this office was being audited. It was normal for the client, and it happens everywhere, to ask the external auditors if they can do an extended work to establish the status of procedures, controls, and so forth. That's what I did. And therefore, it didn't come as an issue of another procurement per se. It was an issue which is professionally acceptable to only extend the scope of the auditor to do this work. Otherwise, it would be, again, me hiring, I would have hired another auditor to come and do the same work, another work for a different, for that amount.
Are you allowed to?
No, I'm not allowed to. If I appoint, I could be allowed, I can appoint like a consultant. I could appoint internal. But there was no, because this is an established, acceptable procedure to request the external auditor, the current external auditor, to extend the scope of their work. And they normally ask, can you pay us a little bit more? The amount, and therefore that payment was from my budget. And it was not 7.2. And I think Baker Tilly is coming here, let them actually say how much they received. It was not that amount. I can't tell you of it.
Auditor General, you know, somebody is accusing you of having paid some amount X.
Yes.
And you should not take it casually that the other person will come and tell. It is incumbent upon you. If you don't have it here, say, I don't have it here, I'll go and confirm the amount. Just, so if you don't have it here, you say, when do you confirm?
He asked about the confirmation of the amount, I will confirm.
Yeah, but, yeah, so that's because it is you to, if you say, if you don't agree with the amount, tell us what was actually paid. And then it will also raise questions of variations of contracts, of contractual values, which I am sure...
was this part of the contract? No, it wasn't.
To me, it appears there's like a variation, you know, no, additional work.
Mr. Chairman, he just said the original works was procured by Parliament.
Yes.
The extension of works was procured by the Auditor General.
Yes.
So it was not a variation.
It was additional work. Or different jobs.
Chair, thank you. Chair, I think what we need to clarify in this matter, Chair, if I may have your attention, what we need to clarify in this matter, Chair, is whether at the time of hiring Baker Tilly Merali as the auditors, the kind of TOR that they were given, and whether at the time of commencing their work, those TORs were changed or varied to accommodate extra work, which probably arose out of what came out as either intervention, yeah, exactly, new interventions coming out of the audit work. You know, I think we just need to get that clarification, because it's possible you may not know to what extent you need to streamline your systems until when you start the work. And if that be the case, and it was realized that they needed to do extra work, that's just the simple clarification that we need to get.
Chair, if the auditors are engaged by Parliament, then they receive their terms of reference from Parliament. Right. So the clarification I require is just two things. One, then if it was that same work and we needed the terms of reference to be added to include internal control systems, is that supposed to be done by the person who has engaged them, who is Parliament? And number two, then if it was a different work that you're giving them, is there not a process of tendering or appointing a consultant to do different work for you? You know, that's the clarity we require. Because if it was Parliament, then that I was paying for an audit, if I say, okay, since you're auditing, I also want you to look at 1, 2, 3, 4, 5 things, which I think is a good thing to do. But Parliament is the one who should then change the term of reference. You know, we just need clarity. Just help us understand. Help us understand.
Mr. Chairman, while I agree that Parliament could actually vary the terms of reference if they did not include it in the original TOR, Mr. Chairman, the recipient, who is the wearer of the shoes, actually knows the importance of those internal audit controls, and they are perfectly okay by drawing the attention of Parliament that there is need to do also external controls, I mean internal controls, and of course normally the external auditors also just do it if it was included in the terms of reference. But in this particular case, it was not included in the terms of reference, and therefore they asked Parliament to allow them, but Parliament said, we can only allow you to give them that extension of that particular clause, which was to review the internal controls, on condition that you are going to pay for them, not me paying for them. I think that was...
I think let's allow the auditor to... Oh, okay, let Shakir. Then I'll come to Limo and then we allow him to...
Chairman, you're an auditor as well as I am, and others. There is internal audit and external audit. Yes? So, whereas external audit does look as internal audit systems, it is not necessary of an external auditor to incorporate internal audit systems, but they can make comments as to what internal audit systems they would like to see. That's one point. The second point is, forgive me for asking this, but I think, isn't there an internal auditor general in this country? Somebody looks at internal audit or regulates internal audit? We have a accountant general. Is there an internal audit general? Yes, exactly. That's what I wanted you to say. Every institution has its own.
But actually, this was not internal audit. It was internal controls.
Other members.
Mr. Chairman. Mr. Chairman. I think what I gather, this was the first audit of the Office of the Auditor General. Parliament appointed DPM to go and conduct the financial audit as external audit, and Parliament paid 7.2 million. In the course of that...
No, Chair.
Please.
Order. I think you are taking us...
Parliament paid.
That must relax. Let us hear Limo. Yeah.
Why Limo before I finish?
No one gave you. I never gave you the Nini before.
Oh.
Yeah.
Chair, the petitioner was we are ordinary form of audit. Review of internal controls is part from the Auditor General here, that whether in the terms of reference which was given to the auditor when he was procured by Parliament, whether internal controls review was part of the work, because the petitioner is saying according to him this was part of the job which he was given, but we have not really clarified that. Everybody is saying that it was not part of it. Who has seen that terms of reference? Have we been given that terms of reference? No.
So, Limo, Auditor General, I think let's to the question of procurement, the question of which the petitioner was saying single sourcing. Number two was that suppose that the same work which you gave him was part of what Parliament had employed him to do. I think that's the other allegation which came, and then he was saying you paid him. The Office of the Auditor, let me put it properly. The Office of the Auditor General paid more than what was originally paid to him to do the work that was engaged to do by Parliament. Procedure.
I've said very clearly this was not part of his TOR from Parliament. So it was an extra work. Now, as to whether it was single sourcing, it never rose the issue of single sourcing, because I said this goes to review, an extended review of the controls, which had been there because this is the first time these people were, or they were in the process of auditing the accounts. Because this office has never been audited by an external firm. So I, as a client, and I think it is a right decision which I took for the office to know the state of affairs. And they said, no, this one would be an extended work. And I said, look, okay, let me ask Parliament if I can go ahead and pay them to do that extended work. And that's what I did. Now, as for the amount, 7.2, we will come back and confirm what amount was actually paid, because I don't believe it was 7.2.
Maybe, Chair, just to add, I'm looking at what has been marked as A1, Chair. Chair, if you look at what has been marked as A1, they are trying to respond, page 19. And at least for now, I'll come to the defense of the Auditor General. If you look at number 4B, it says we refer to the contract for the external audit services with Parliamentary Service Commission, section 322, which allows for consulting services. I think the Parliamentary Service Commission has a contract with these auditors, and part of that allows. And I think that is why he was seeking for that, based on the comments which were given by the external auditor, which is here. So it says under the contract given by Parliamentary Service Commission, it does under section 322 does give permission, or it just gives a provision for consultancy, which is part of the contract that Parliament gave for them to audit the Auditor General. So at that point, so at how much it should have been, maybe now that remains now the question. As regarding whether there was any due diligence done by him, which was there, and also following the contract that was signed between the auditor and the Parliamentary Service Commission.
Also, then I'll...
Chair, just to pick up from what Mheshimiwa Gikaria said, and probably I'll request members to look at page 19. And that's, I think, a response from Bekatili Merali. If you flip over that page, it gives very clearly the circumstances under which that work was undertaken. And if you look at section 6 of the petition, I mean, if you look at that is section 4E, as a result of having several consultative meetings between the auditors and the Office of the Auditor General, I think certain issues emerged, and this is what I was referring to when I initially talked about under what circumstances did we have the extra work required. And it says very clearly that out of those meetings, you know, certain things were now clear that probably the scope of work needed now to expand to include issues which emerged out of those meetings. And it says very clearly, it goes further and says that parliamentary approval was actually sought. There was no objection to that effect. To review, the word here is review, systems review scope was outside the original financial audit scope. So reviewing the system was actually outside the original financial audit scope, okay? And therefore, based on that, I think it's clear why the extra work was necessary.
Maybe as we, members, maybe as we proceed, there was some allegations made by Honorable Dalmas Otieno that the audit reports of the Office of the Auditor General have not been tabled by in the House. But we have, what is this? We have the answer for Thursday, December 1st, 2016. And among other things, on the section of papers late, the following papers were late. One, the financial audit of the Office of the Auditor General, Kenya National Audit Office, Kenao, by the Government of Kenya through Parliamentary Service Commission for the period from 1st July 2011 to 30th June 2012. There is another answer for November 24, 2015. Among other papers late were the report of the Auditor General of the Kenya National Audit Office, Kenao, for the period from 1st July 2012 to 30th June 2013. Then another one for Wednesday, July 20th, 2016. July 20th, 2016. Among the papers late was the audited financial statements and management service report by independent auditor on the Office of the Auditor General for the year ended 30th June 2014. So the financial, the audit reports, yeah, of the Office of the Auditor General have actually been tabled. Order. It is Honorable Dalmas Otieno who was not aware. You are the one making those allegations. I was just reminding Dalmas. So members, so can I say, do any other member have a question on this subject to, of course, provision of the exact figure which was paid because he is in contention of the amount? So you think in terms of the procurement process, you think that was followed properly? Okay. Let's go to, maybe it should be unanswered because when you have questioned to me, which I understood, but these proceedings will be followed several years down the line. So you think the procurement process for these extra works were properly done?
Yes, Chairman.
Okay, thank you very much. Now let's go to point 7 and the others.
The petitioners issue of paragraph 7 or number 7, okay? Now, really, I would say I'm a stranger to these allegations, and would like to hear more about them if he has. And as for my traveling and private trips, I don't believe I've made any private trips on the basis on public funds.
Are you able to give us your schedule of travels? Say for which period was it mentioned? 2014. Okay, around maybe 20 from your appointment. From your appointment to say the last three no, from your appointment to date, is it possible to obtain these are the days you travel for the purpose of what conference? Is it what are you able, so because now, so that we clarify that even if you travel, by the way, you can travel today and tomorrow depending on depending on the need, yeah, but the allegation is you've made several travels. Some of them are more private Yeah, that's the allegation. For reasons that are more, are for reasons that are more private than official. Of course, I know the other gentleman should bring us what he thinks were private.
Yes,
trips, yes,
but I think it is better for the petitioner to identify which were the private trips, because as far as I'm concerned, all the trips I've done are official.
That is of course on public on public funds. Of course, you may have made your own private travels funded by yourself. But for the purpose of this committee, it would be good if you give us a summary of all your official travels, dates, and summary of conference in South Africa, conference in.
Yeah, I think we have to be fair on me here. Somebody is coming to claim, making a wild allegation that I have been traveling on private travel.
This is NTV.
The process of due diligence is very important and must not be taken lightly. It involves understanding the condition of the property, the state of the title deed if the property has existing owners, and its complexity.
Buy an 8th acre in a new